And we've been talking for quite a while now about the concept of nullification, which is something that is a crazy concept come up with by James Madison and Thomas Jefferson. You know, the guys who wrote the Constitution and the Declaration of Independence. And they had to deal with some of the same kinds of issues that we're dealing with now, with the federal government out of control, doing things that were in direct violation of the Constitution. So there's nothing new under the sun. You know, in fact, they ought to have known better, because when they did this, I mean, the Constitution only been ratified in a few years. And who knows about the Alien and Sedition Act? A few people have.
Adams administration.
Adams administration.
Yep.
Now, if you watch the Adams miniseries that put on HBO, was really good. Wow. They kind of gloss over this part of the story of the of John Adams. A little background on how this came to be. And it's a lot of political intrigue and so on and so forth. But basically, there was a lot of infighting in Washington. So John Adams thought it would be a spiffy idea to pass the Sedition Act. And basically, the Sedition Act, for all intents and purposes, made it illegal to criticize the government. Made it illegal to criticize the government. And it wasn't like just something that they did and made a law, but they threw people in jail. They threw journalists in jail. They actually threw one congressman in jail. So that's where the concept of nullification came to be, because Thomas Jefferson wrote the Kentucky Resolution in 1798, and James Madison wrote the Virginia Resolution in 1798, which lays out the concept of nullification. The Supreme Court does have the right to do something when there's a conflict between two states, right? That's the way the Constitution is written. If there's a conflict between two states, the Supreme Court can rule on that. But does it say anything in there about what happens if there's a conflict between the states and the federal government about the role of the federal government? There isn't anything. So basically, what we've been doing, like you look at the Cuccinelli lawsuit, for example, we're going to the federal government to ask them to restrict their own power. How often has that happened in this country's history? How often does a government entity self-regulate itself? Does that ever happen? I mean, out here it's funny when Judge Roberts will do it. I mean, we got to get good people in the Supreme Court to do stuff. Who's the person who wrote the goofy Supreme Court decision for Obamacare? We've got a PowerPoint presentation, but this is a movie made by the 10th Amendment Center. This is a national group that, has anybody read Tom Wood's book on nullification? Tom Wood, one person has. Tom Woods is a fabulous author, one of the best conservative writers in America right now. And he wrote a book on nullification, which a lot of this information is called from. And this is about 8 minutes.
The rules. When government does not follow the rules given to it, what do you do about it? Do you march on Washington, D.C. to beg federal politicians to limit their own power? Do you go to federal court in the hope that federal judges will limit federal power?
Many of you have asked, what can we do now about the loss of freedom? We can persuade the state governments to defy the feds in areas like health care, where the Constitution gives the federal government zero authority, and to nullify all the laws the Congress has written that are not based on the Constitution.
And for the sovereignty of the peoples of the states. No government is sovereign. That's the old world European model that Americans fled from. It's the peoples of the states who are sovereign, and in their sovereign capacity, they apportion powers between the state governments and the federal government. And in so doing, they don't give up their sovereignty. They are merely exercising their sovereignty. They retain ultimate decision-making power.
The amazing thing is that I think people forget that that puts the federal government at the bottom of the ladder. I mean, the individual gave authority and responsibility to the state government, which then gave responsibility to the federal government. So it's been flipped.
So if the agent that they themselves created, namely the federal government, should go beyond the powers granted to it by the sovereign peoples of the states, then the very logic of the system demands that the sovereign peoples of the states, by virtue of being sovereign, have to have a last resort mechanism for intervening when their own system perverts its instrument, namely the Constitution.
Jefferson said, an act of Congress which assumes power not delegated by the Constitution is not law, but it is altogether void and of no force.
The federal government, said Jefferson, cannot have a monopoly on determining what its own powers are, because we all know what it's going to do. It's going to suddenly determine that it has more and more and more and more and more powers. It's going to keep on discovering these vast, untapped reservoirs of power. We all know this. I mean, this has happened. It's not like I'm talking theory up here. Just look around, look at the Constitution, then look at what we live under. This is what has happened. So it's not enough to say, well, gee, you know, it would be nice if they would listen to the Constitution, then the government would be more limited. Yes, it would be nice. A lot of things would be nice. But power has to counteract power. You can't expect the 10th Amendment to enforce itself. The states have to assert themselves. That's the idea behind state nullification.
George Nicholas, who became the first Attorney General of Kentucky, who also served on this five-man commission, said, oh, and by the way, if the federal government should try to reach for any supplementary condition, those were his words, to impose upon us, we will be, in Virginia, exonerated from that additional power because we never agreed to it. We're only agreeing to the powers in Article 1, Section 8. Well, there's nullification pretty much in germ right there.
The Virginia and Kentucky resolutions of 1798 are some of the great forgotten documents of U.S. history. They were written by James Madison and Thomas Jefferson, respectively, and they spelled out what cumulatively we know as the doctrine of nullification. Madison in the Virginia resolutions and Jefferson in the Kentucky resolutions were looking to consider what to do when the federal government violates the Constitution. And Jefferson even used the word nullification in his draft of the Kentucky resolutions, and then they appeared the next year in the 1799 Kentucky resolutions. Basically, they're saying this is a limited government, has only the powers granted to it, and so if it exercises a power that wasn't granted, then the states should refuse to enforce it. And then in 1800, Madison followed up with the famous Report of 1800, in which he said that ultimately, in the last resort, even when all the courts have heard whatever the case is, everything has already been accomplished in that way, there are still cases where, you know, the courts might also betray us. So what can be done in a case like that? And Madison said, the parties to the Constitution, by which he means the states, have to be able to intervene at that point and say, wait a minute, we created this thing in the first place, so we know firsthand it was not intended to have this power, so in the last resort, we are intervening to stop it.
In the Virginia resolutions, we learned that when the federal government goes beyond its constitutional powers, that the states are duty-bound to resist. Now notice he didn't say, well, you might consider resisting, or maybe you could flip a coin, and, you know, if it comes up heads, you would resist. The states are duty-bound to resist. Thomas Jefferson, who drafted the Kentucky resolutions of 1798, in his initial draft, as well as in the follow-up resolutions of 1799, said that a nullification is the rightful remedy in a situation like this. Virginia issued a report, sometimes known as Madison's Report, following up on the Virginia resolutions of 1798. And in those follow-up resolutions, Madison clarified that we need a remedy for when even the judicial branch betrays us. So it's not enough to say, oh, the courts will put things right. That's not what Madison thought. We need a remedy for when the courts betray us. The courts are not composed of infallible human beings, because there's no such thing. In fact, think about Thomas Jefferson's attitude toward the federal courts. His argument was the federal courts are part of the problem. Now, you want me to go and refer my disputes to them? They're part of the problem. The problem is the federal government, and last I checked, the federal courts are part of the federal government. They can't possibly be impartial arbiters. Let's suppose you and I had a dispute. I know this would never happen, but let's suppose we did. And then I said to you, I have just the person to adjudicate this dispute. How about my mother? Now look, my mother, you know, she's still alive, and I want to say in her honor, and with respect to her, she's a very fair-minded person. She might side with the other guy. I wouldn't bet on it, though. I mean, you know, we have known each other a long time. So, in other words, this is clear, right? You don't, when two parties are having a dispute, you don't let one of the parties in the dispute render the decision. And so the idea of state nullification, that the states formed the federal government in the first place, they are the principals. The federal government is merely their agent. The employee does not tell the employer what to do. Try doing that, by the way. See what happens. That is not how it is supposed to work. If it is going to be limited, if that's even possible, obviously something outside itself has to do the limiting. Just common sense. Well, according to Jefferson, the logical candidate for that role would be the states. That is their role. As the principals to the compact, they determine when the compact has been broken.
I would just urge that we look to history and find what was nullification used for. Well, was it used to oppress minorities when it was introduced? No, it was used to fight for free speech and free trade and against unconstitutional searches and seizures, against the fugitive slave laws.
If you look at history, you will find that the people that were supporting the idea of nullification, the people that were pushing the idea of states' rights, were the northern abolitionists, because they didn't feel like the federal government should be able to force them to be slave catchers and force them to send people back south who are looking for their freedom. And if you look at the list of causes that South Carolina published before they seceded, one of those things was that those pesky northern states were nullifying the fugitive slave laws. Nullification is not about slavery. Nullification is about freedom.
What can we do now about the loss of freedom? We can persuade the state governments to defy the feds in areas like health care, where the Constitution gives the federal government zero authority, and to nullify all the laws the Congress has written that are not based on the Constitution.